Good evening, everybody. Thank you for coming tonight to the Fleased Forum, Shenango County. My name is Mina Takahashi, and I live in Oxford. My husband and I maintain a 106-acre organic farmstead, and we love Oxford, and we love this whole region. We moved here in 2007, and when we were checking through all the deed papers, we noticed a very old gas lease. It had expired in the 90s. And we were concerned, but our lawyer at the time told us if we had just had the previous landowner file an affidavit with the county clerk's office saying that there wasn't a well or there wasn't any activity on the property, that everything would be fine and closed out. So the previous landowner did this, and we were satisfied. But then, as you know, this was the end of 2007, right in the spring of 2008, 4 months after we got here, the whole gas rush erupted in Pennsylvania, was starting to come into the southern tier, and we were concerned again. So we contacted Fleased.org, and Joe and Ellen let us know that really we were not safe with just that affidavit on file at the county clerk's office, and they helped us take all the steps necessary to cancel out our lease. And I'm happy to say, finally, Tuesday, I filed those papers at the county clerk's office. So I really want to thank Joe and Ellen for all your help in doing that. So you can guess from my comments that I am of the mind that high-volume hydraulic fracturing is definitely not something I want to see on my property. But I want to be clear that this forum is for everybody, no matter what opinion you hold on this issue. And we know this is a contentious issue, but we want to keep this, the presentations and then the questions, that period, we want to keep it very respectful, and keep in mind that we're all here because we love this community. And I think that we can all agree that as landowners, we have rights and we have responsibilities to the land that we steward. And we also have responsibilities to the investments that we've made on our properties and to the community that we are a part of. And to make these important decisions, we need good information. And we're very lucky tonight to have Ellen Harrison and Joseph Heath here to share their expertise and their experience with this issue. So before we start in on the program, I just wanted to first acknowledge the community organizations that put this together and called in all of our neighbors. I'm part of Concerned Residents of Oxford, and we're a collective of neighbors in Oxford, and we work together to educate ourselves and educate our neighbors, and we work also regionally and statewide to effect change. Our co-sponsors tonight are Sea Dog and Sea Care. So now I'd like to introduce our presenters tonight. I'll go through these and then we'll move right into the forum. First, we'll have Ellen Harrison. She's a geologist and environmental scientist. She retired a few years ago from Cornell University, where she directed the Cornell Waste Management Institute for many years. She and her husband signed their 33-acre property to gas leasing before shale gas development was under discussion. She came to regret leasing her land and formed Fleased, an organization to help disseminate information about landowner rights regarding gas leasing issues. She now lives in the town of Caroline. Next is attorney Joseph Heath, who joins us from Syracuse. He's been general counsel for the Onondaga Nation since 1982. His work centers on environmental protection, particularly under the Clean Air Act. He also works to protect hunting and fishing rights, treaty rights, and land rights. Over the past 5 years, Joe has been researching issues of shale gas development and has been helping landowners understand their rights, and helping them to terminate their leases and to manage the many questionable ways that gas companies are seeking to extend old leases. So to conclude, on behalf of concerned residents of Oxford and Sea Dog and Sea Care and Fleased. Really want to thank the United Church of Christ for hosting this event. They've been terrific in terms of providing the community space for us to educate ourselves about these issues, and also helps us to bring us together to discuss these difficult subjects that impact the entire community. We're grateful to them for offering this beautiful room, and I especially love the idea of Ellen and Joe speaking truth to power from this altar.
Thanks, Mina, and thanks to all of you for being here. My name is Ellen Harrison, and as Mina said, I'm an environmental scientist, and my husband and I have 33 acres of land in Caroline, which is over in Tompkins County, southern part. And in 2008, 7, landmen came to our door, as probably came to many of your doors, and we thought about it. We knew nothing about hydrofracking, and we felt, gee, we use energy, we shouldn't be NIMBY. And yes, he offered us some money. It wasn't a lot of money. And we ended up signing a lease. And then not that long later, maybe 6 months later, the issue of hydrofracking came to the surface, as it were, and my husband and I were really quite horrified about what we learned about the process. And I realized that if we had signed a lease in ignorance, that most people who signed leases were signing them in ignorance, and that many people who signed them not only were getting very little in the way of money for their mineral rights, but that they also signed leases that gave away an awful lot and put them and their communities at risk. And as with Mina, my view is there is no such thing as a safe way to develop shale gas. But my presentation is not predicated on that. And there will be people who don't agree with that but still have lease concerns. So there are flyers in the back about Fleased, the organization. We have a website which has a lot of information on it, and I would urge those of you who are able to use the internet to go there. A lot of what Joe and I are talking about is further explained on that website. There are sample letters that you might be wanting to write or use, etc. Most of us who signed leases feel like we were snookered, and that's a shameful feeling. We got taken advantage of. I don't even want to think about it. And it's a lot of people, I think, don't want to look at their lease because it feels painful to look at that lease. But as Joe and I will explain, those of us who signed leases, we were duped, and it's time for us to respond and get angry about it, not to hide our heads in the sand. Can I ask how many of you have gas leases on your property? Probably about half to 2/3. Okay. So I say we were snookered. It was pretty funny, if you want to think that way. There was a booklet found on a driveway in Ohio that one of the landmen, so a landman is a salesman. Basically, gas companies hire a contractor to go out and get leases signed. And this handbook basically was a crib sheet for how to snooker people, how to get people to sign leases. And basically any of you who signed know there was a lot of pressure put on you. Sign today, we can't wait, we can't make any adjustments in this. All your neighbors have signed, so you might as well sign because we're going to drill under your land anyway and get your gas, and this way at least you get some money for it. Sell it as patriotic, right? This will be a homegrown source of energy. And frankly, that is still being talked about nationally. But the reality is, at this point, gas prices in the US are very low. Gas prices in Europe and China are much higher. And the federal government has approved some, and there are permits in the process to approve facilities along the shores where you can liquefy gas. You can't ship gas overseas, but you can compress it into a liquid, and that liquefied natural gas can be shipped overseas. And frankly, what do you think? If you're getting, $3, $2, a million cubic feet here, and you're getting $16 in China, where's that gas gonna go? I know ours, we're a small company, we're a family-owned company. What they don't tell you is that leases, in fact, become a commodity that they trade and they sell. And most of our leases have no restrictions on who they can sell your lease to, and they don't even have to tell you whether they've sold it to somebody else. I know we asked about water. Don't worry about it. No, we're not aware of any contamination. I asked them how long it was going to be active if they drilled a well. And he said, a couple weeks. Well, what they don't tell you is maybe it's a couple weeks to a couple of months for one well, but on most well pads, they're looking for a permit for 6 or 10 or 12 wells. So it's likely to continue to be an active site for many years. Many of our leases were for a 5-year term, and then in the fine print it says, and the gas company can extend it another 5 years at their own discretion, simply by paying you whatever they paid you in the first place. So there are a lot of clauses. My favorite one is when people brought up radioactivity as an issue. They can honestly say, we don't use radioactivity, which they don't. But what they don't say is that the rock materials and the water and the gas that come out of the shale deposits are radioactive because that radioactivity is part of the shale itself. And in bringing it up to the surface, you're bringing up radioactivity. So sometimes they blatantly lied, but frankly, one of the things we were very disturbed to find at Fleased, a couple of years ago, we were trying to see if we could bring a lawsuit because we were misled and lied to, some of us. And the answer is, if it's not in the lease itself, if he just lied to you verbally, nothing much you're going to be able to do about it. And one of the things that the lawyer we worked with said, which is heartbreaking but true, is something that is wrong and unjust is not necessarily illegal. And all you can do is go to court over something that's illegal. Joe's going to talk more about this, but basically the first clause in a lease tells what they can do. And for those of us who signed a standard lease, they can do pretty much everything except take your firstborn. But basically, most of the leases, again, not only give them the right to develop gas, but also to construct pipelines. And frankly, anytime they put in a well, they have to put in at least a gathering line. They have to be able to move the gas off your property. They can put in roads. Many of them can put in compression stations, which can be big facilities and have significant air pollution issues and noise issues. And many of them allow them to then use that well once it's stopped producing to pump gas back down and store gas. And one of the things that was eye-opening as I've begun to collect information about what it means to have a lease. There are mortgage issues. Have any of you had any issues trying to get a mortgage on leased property or a home equity loan? Good. Banks, in order to give a mortgage, mostly they end up selling those mortgages on a secondary market. So you may get it from a local bank, but they're going to sell that mortgage. And in order to sell a mortgage, they have to meet standards of the industry. And those standards tend to be set by Fannie Mae and Freddie Mac. And the documents that Fannie and Freddie have put forward basically require that there'll be no penetration, I think is the word they use, no gas development within 200 to 300 feet of any residential structure. And de facto, that kind of means if you drew a 5-acre circle around the residence, there can be no gas development there if you're going to get a mortgage. And most leases do not have that kind of a setback. And the DEC at this point, as you probably all know, things are in flux in terms of regulations. But what has been proposed in the environmental impact statement is a 100-foot setback, not 200 or 300 feet. So that's an issue that is sometimes coming up when banks are paying attention, and they're beginning to pay attention more. The other thing that amazed me, I didn't believe it until I had it verified by a number of people, is whatever the condition of your property when you sign the lease, okay, but suppose you want to put in a new house for your kid, you want to put in a new barn, you want to improve a field. The gas company basically has the rights to use any of the surface of your land that was not developed at the time you signed that lease. So they could, in fact, come in and say, you know, funny thing, that's just where we wanted to put a well pad. They also, not only can they go anywhere on your land unless you've specified otherwise, they also, in most leases, there's no restriction on the number of acres they can take. So on my 33 acres, I didn't write in a restriction. I visited a compression station in Pennsylvania that was bigger than my whole property. It was a large one. It seems hard to believe, but in many leases, they could come in and they could basically take, 20 acres of my land if they wanted to, or 30 acres, everything but my house. We also discovered and have been thinking about liability issues. So as you know, you can be sued by anybody for anything. It doesn't mean they'll win the lawsuit, but you still have to spend money to defend yourself. And again, most leases have no indemnification would be the word, nothing that says the gas company will be responsible for anything that happens and they'll defend me and I'm not responsible. There's apparently a case in Pennsylvania where a worker was killed, and that was a gas worker, was killed on a site, and the family sued not only the gas company, but also the landowner. I don't think they'll necessarily win that suit, but the landowner has to deal with it. And those of us who have, everybody who has a loan has homeowners insurance. Our homeowners insurance has nothing to do with this kind of gas drilling. Homeowners insurance, in fact, some of the companies are now refusing to give homeowners insurance to people with a gas lease. Just as if you had an industrial facility on your property, homeowners insurance is not meant to cover that. So the insurance industry is just starting to kind of wonder what they're going to do about it. I just learned in the last couple of days that the federal, flood something or other management agency, FEMA, which deals with flooding. So poor Pennsylvania and Southern Tier, there's been some significant flooding. And I guess that FEMA will sort of buy out people's properties. But apparently if you have a gas lease with surface rights for a gas company, they say we can't buy it out because you don't own it strictly. The gas company also has an interest in it. So this is a brand new ugly wrinkle. I think, Joe, you're going to talk about when does a lease end a bit? Okay. So I mentioned that there's an extension clause. Joe's going to talk about continuing operations. If things are going on, they can keep your lease open. Joe's going to talk about force majeure. This is a clause that is in many leases that basically says the gas company, I can extend your lease if an act act takes place that keeps me from fulfilling my requirements to drill. Joe will talk more about that and why that's bogus. And there's quite a bit on the Fleased website about force majeure. Joe's going to talk about this. Chesapeake recently has sent more letters out to people claiming force majeure, misusing language in an agreement, a lousy agreement that the New York State Attorney General entered into with Chesapeake. The AG's office, Joe and I met with them, 2 years ago? I think it was 2 years ago, to try to push them to do something for all of us. And what they came out with to us was worse than nothing. Very disappointing. This I'm going to talk about a little more. Most of our leases talk about unitization. And what that means is, when a gas company wants a permit, applies to DEC for a permit, they go in and they've drawn on a map an aerial extent for which they want to get that drilling permit. That is the unit, the spacing unit. State law says that unit can be anywhere from 40 acres to 640 acres. That's a square mile. It's not square necessarily. 640 acres. The gas companies tend to apply for the larger area, and the way the law goes is the gas company has to have either ownership or leased the mineral rights to 60% of the area in that spacing unit, not 60% of the owners. So one owner may have a very big piece, and there may be a lot of owners with little pieces, but if 60% of the land is under the gas company's control, then they can get a permit. And the other land, 40% or less, and however many owners that is subject to something called compulsory integration. In other states, it's called forced pooling. Basically, it's eminent domain. The gas company gets eminent domain. And that is one of the ways that they sold us on signing a lease, is they basically said, hey, your neighbors have signed, so we're going to drill here if we want to, so you might as well sign up. And this compulsory integration, it's interesting. The law was passed, 2005, I think? And in 2005, the legislature was not thinking fracking. The gas companies were, but the legislature wasn't. And in the old-fashioned gas wells, some of which are still being drilled, it was more like sticking a straw down and hoping you hit a pocket or a crack where you could suck gas out. And if that crack went from my property onto my neighbor's property, and you stuck the straw on my property, you could suck the gas from my neighbor's property. And prior to that law, your neighbor would have gotten nothing. So they passed this, I think most of the legislature, thinking that it was going to be more fair. That this way, if you're sucking gas out of my property and you're also getting gas from my neighbors, they get some money for it. What is screwy about this is the technology for hydraulic fracturing would enable us to get gas, but only get gas where you can drill and crack the rock. The gas is actually held in tiny bubbles in the rock. So it's not the same kind of thing. It's not like a straw goes down and you suck it and it comes out. You've got to drill it, you've got to fracture it with this high pressure fluids. And what that means then is you're only going to get gas where you drill and where you frack. And the technology is so good that I can actually drill around my neighbor's property. So if my neighbor doesn't want fracking on their property, the driller can go down on my land, can avoid their land underground. And frankly, all of us who own land, we own down to the center of the earth. So it's not just, they can't go on the surface of my land with compulsory integration, but they can drill my land down below and frack it. So it's not a necessary thing, but it's happening, compulsory integration. And there's really, at this point, it's going to have to be fought as a legal battle. If DEC comes and says, you're going to be compulsorily integrated into this spacing unit, there's a hearing, but the hearing is not about whether it should happen or not. The hearing is strictly about how do you want to get part owner of the well? Do you want to get just 12% royalties? It's only about a choice you would make about how you would, to me, be screwed. There's also no requirement for anybody to tell you that you're part of a spacing unit. Now, if there's compulsory integration, they have to tell you, and you have, I think, 28 days before you have to make this decision about how you want to be integrated. But if you have leased your property, nobody has to tell you when the gas company applies for a permit. Nobody has to tell you that you're being unitized. There is a DEC database. It's a searchable database, and one of the things Fleased has been talking about, but I don't have the personnel at this point to do it, is to try and get notification going to people so we can tell people in different communities when permits have been applied for. I want to address a little bit people who are considering entering a lease. Some of you whose leases are expiring may be considering entering into a new lease. There are joint landowner coalitions. Have you all heard of them? Nod your head. Yes, you're familiar. These landowner coalitions are predicated on the idea that there's strength in numbers. And, you know, each of us, there's no way, my lawyer didn't know anything when I asked him about signing my lease. More lawyers now have more information, but they're not experts. And so the idea these landowner coalitions have is, one, we can negotiate for more money because we have a lot of acres under our, not control, but under our, joint efforts. And similarly, we can get a really high-powered lawyer who's going to think this through and write a good lease. But one of the things that should give one pause is the coalition leaders and the lawyers for the coalition get their money when a lease is signed. So they have a very strong interest in getting a lease signed. Now, in these coalitions, it's my understanding that you can sign up to be part of the coalition, but you don't have to sign the lease. When the lease actually comes forward, let's say a gas company says, yeah, we're interested in signing, which they aren't right now, but suppose they were, you don't have to sign it. You have a choice. But the reality is, the reason you've joined the coalition is you want to have their lawyer be smart and know what to put into a lease. You don't have that knowledge. I don't have that knowledge. And probably your family lawyer doesn't have that knowledge. So you're kind of trusting them. And I guess I would say, since their money comes when a lease is signed, I'm not sure that they have your best interest necessarily in mind. Leases, gas drilling is an industrial process. There will be risks. There's no doubt about that. And what we have to face is that even a very well-constructed lease does not prevent harm. What it does is give you legal standing to fight if there's a problem, if they violate the lease in some way. So you have to be prepared to go to court if you need to enforce it. Let's say you've told them that they can only use a certain part of your land, but they go somewhere else on your land. What are you going to do about it? You're going to have to go to court. And they got a lot of big bucks, and you don't. In all the thinking about leasing, there's a lot of talk about gathering baseline data. You better know what the quality of your well is, what the quality of your soil is, what the health of your family is before they drill. And my question again to you is, who is going to collect and analyze those data? What happens if your well goes bad? You all, I'm sure, have read. It goes bad, and the gas company says, not me. And I worked in groundwater pollution, part of a state agency for years. It's very hard to prove who done it. How are you going to prove that? And if you do prove it, let's say the gas company has contaminated your well, what are you going to do about it? Delivering carboys of water is not a solution in the long run, and you really can't fix it once your well's contaminated. So it really bears thinking that even a good lease has a lot of potential glitches. In leasing, consider your liability, write an indemnification paragraph. But one of the things I learned to my amazement was in New York State, a contractor is not responsible for the actions of his subcontractor. So the gas company is the contractor, that's with whom you have the lease, but there are as many as 40 subcontractors working on a well site. The guys who truck stuff, the guys who actually do the drilling, the guys who transport the chemicals. There are lots of people working on that site. And just like that BP offshore issue, they're each going to do this. They're going to point at the other guy. It wasn't my fault, it was his fault, it was his fault. So it ain't so simple if you're writing a liability clause that says it's not that simple. What are we going to do? Well, Joe's going to talk with you a bit about what you can do if your lease is coming to expire, how you can actually get free and clear. I would urge people to talk to their neighbors because, as I said, a lot of us who signed leases, we're ashamed of it. We don't want to talk about it. We don't want to admit it. But it's something we do need to face. And for me, at this point, politics is one thing. I don't think there's going to be a lot happening in the legislature. I think putting some pressure on the governor is well worth it. He's, at this point, the one who I think is calling the shots about whether there'll be a moratorium or not. To me, one of the most important things we can do is try to get our municipalities to pass a ban. Because frankly, that's the only thing that's going to really protect us, those of us who have leases, is not to see gas drilling happen, and the only way we can sort of be sure of that is by doing a local ban. There's a packet in the back that looks like this that says how to use this packet to inform town officials about the plight of landowners with leases. Frankly, a lot of the people on town boards have leased their land. And I don't think they understand the kind of impact that drilling might have on their own properties. People don't want to believe it. And this packet, which is also on our website, has a few sort of one-page summaries, and I should be doing a few more, that talk about what are the challenges as people with gas leases. What challenges do we face? What are some of the mortgage issues? What are some of the insurance issues? I need to write one up about the real estate issues in terms of where on your land they can go. So I frankly think I'm delighted that in my town we had a town board election a year and a half ago, and we elected a board that wanted and then passed a ban. And there also is a handout that follows what Joe is going to say about how to terminate a lease when it's expired. If you have the internet, I'd urge you to access it that way rather than take a paper copy, but if you need a paper copy, there are some at the back. I think at this point I'm done for now, and Joe is going to speak, and then we'll do questions. Thank you very much.
I've been studying leases My office is in Syracuse, but I live in Cortland County. And there's a gas group there, and one of our members about 2.5 years ago started to try to end his lease. And in the 6 months that it took him to do that, together we learned about how the New York law is very, very difficult for landowners to end leases. Your lease doesn't end automatically. That's one thing I really want to stress. You have a lease that says, I signed the lease in September of 2007. It has a termination date. That doesn't mean that it's over. It's still filed in the county clerk's office. It's still a lien on your title, and you have to take action. So as we learned about that, it became pretty clear that a lot of people needed to learn the same things that we had gone through. And so that's how we get to be doing these workshops. And in the process of doing that over the last 2.5 years, I've attended dozens of these kinds of workshops. I've looked at hundreds of leases. I've had a lot of people come to my house, my neighbors with their leases. And kind of universally, people feel chagrined, as Ellen talked about. How could I be so stupid? I'm guilty. How could I do this to my neighbors? Why didn't I know more about this? And you really, what I want to do at the beginning part of my talk is help you understand the corporate business model that your lease fits into. Because it's really important to understand the commodity aspect of these leases. And so that's what we'll do, at least initially, and then we'll go into the New York law about how the steps you have to take to end leases, and a few other things along the way. So these are not your grandfather's gas wells. I remember when my brother-in-law, who lives about a mile to the west of me, right on the Cortland-Onondaga line, asked 6 or 7 years ago, should I sign a gas lease? The conventional wisdom then was, particularly in the rural parts of the state, almost everybody had a gas lease. And we knew about these little old wells, and they were they weren't very obtrusive. You can see from this that this is not what we call your grandfather's gas well. Just, I don't know if you can see, all of you can see this. This is a house. Look at the size of this compared to the house, and imagine what the life is like in that house. And, you know, just today, this afternoon, as I was trying to pack up and come over here, I found just another incident that yesterday in Pennsylvania, in Washington County, in a town called Takahashi, probably related to the Native Americans that used to be there, there was a well explosion, and gas and fracking fluids were released, and 4 families had to be evacuated, and that story is developing as we speak. These are industrial processes. You don't want them right next to your house. You don't want them on your farm, and that's what people are learning. That's probably why most people are here. Just briefly, what the gas companies are doing now, they've got all the easy gas. Ellen talked about just sticking a straw down. What they used to do up until about 10 years ago was just find pockets of gas, drill down into the pocket of gas and pull the gas out. They've got all that gas. And so now they're way out on the extreme edge of engineering in order to get the gas out of microscopic pockets in millions of year-old shale formations. And this map is a map of all of the shale formations around the country that gas companies are targeting. So this is the Marcellus and the Utica combined. You can see why we're such a target. It's the biggest area in the country, and that's why there's such interest in it here. These are maps taken from the DEC Supplemental Generic Environmental Impact Statement, the SGEIS it's called. And the reason I show these is that gas companies are fond of saying, even when they're signing leases, oh, we're not going to drill here. Well, then why are they spending money on leases? And the answer is, in fact, we had a driller come to the Cortland group when it was first formed about 4 years ago and say, we're not going to drill in Cortland County because the Marcellus shale, the one that we've all heard so much about, is too shallow. It has to be at least 2,000 feet deep in order for them to frack. And this is the 2,000-foot depth line for the Marcellus. So you can see that most of the area north of there can't be fracked in the Marcellus. The problem with that is that it doesn't give you the whole picture, because underneath the Marcellus, about 3,000 to 4,000 feet deeper, is another layer of shale, the Utica shale. That's what they're after here. Because here's the 2,000-foot mark for the Utica. So that's just something that we need to keep learning about. This is Cortland County. As I said, I live in Cortland County. This is a map that the newspaper ran after the county planning department looked up all the leases. The brown areas are leased. The green areas are state forests. You might think they're safe. The DEC is leasing state forests. And 48% of our county is leased. 48%. But the paper also revealed that it was only 8% of the landowners that had leased that 48%. It's big landowners that are doing most of the leasing. And so it's not really democratic when half your county is leased by fewer than 10%. And if you factor in that you probably have as many citizens who don't own property as do, you probably have less than 5% of the people leasing half the county. And what concerns me and a lot of our neighbors, most of us here have private wells. It took me a while to figure out that people who live in cities don't understand individual water wells. It took a New York Times reporter a day and a half to get it. But where we are, this is a sole source aquifer. The yellow is a sole source aquifer. And so my well is in that aquifer along with 40,000 other people. 30 feet deep. It's a glacial, very shallow aquifer. It's the only source of water we have. One mistake in that aquifer, our wells are gone. And aquifers are getting polluted routinely in the states where the fracking is going on. Now, I know Chesapeake is not as active over here as they are in the part in Cortland and Onondaga County. Chesapeake has 70% of the leases in Cortland and Onondaga County. I talk a lot about them for a couple of reasons, because locally they're the company that affects most people. They also have a very loudmouth CEO, about to be a former CEO because he was forced to resign for a number of reasons, and because they're engaged in some of the worst business practices. But over here I understand that Norse is a big leaser. We'll talk a little bit about Norse bankruptcy at the end, but the business model that I'm going to talk about, that it's important for you to understand, is common to all companies. Chesapeake takes it a little further than others. So in order to get into this shale business, Chesapeake and Norse and a lot of other companies went out and grabbed a lot of leases. That's why the landman came to your door. They spent a lot of money getting leases 2005, 2006, 2007. And in companies that are sold on the on the New York Stock Exchange have to file regular SEC statements, pretty lax rules, but they have to talk somewhat about their business model to investors and regulators. So in 2010, Chesapeake said we engaged in a land grab aggressively. And in fact, they called it the gas shale land grab of 2006. And so they went out and got as many leases as they could with all of the tricks that Ellen talked about, and have almost 15 million acres now. Now they're trying to sell them off because their business model is not working. But we'll come back to that. And So what they do is they grab as many individual leases as they can. Just think of this as a big monopoly board where your lease is one of those little green houses. If you get a big enough pile of those little green houses, you can make a lot of money selling off portions of that. And that's what Chesapeake's business model is. And I'll explain that in a minute here. So they buy leases for as cheap as they can, using some tricks that they're now being investigated for in other states. And then they sell off portions of those to foreign corporations in order to fund their leasing practice. I'll see if I can explain that a little more as we go on. For instance, in 2010, Chesapeake sold all of their leases in the Fayette Shale, which is down in Arkansas, to BHP Billiton. That's an Australian corporation for almost $5 billion. Last March, their CEO, Aubrey McClendon, told Rolling Stone magazine, the primary profit in fracking comes not from selling the gas itself, but from buying and flipping leases. And what he means by flipping leases is, I assure you that buying leases for X and selling them for 5 to 10 times X is a lot more profitable than trying to produce gas at $5 or $6 a million cubic foot. Actually, gas is now below 3. And so when they're drilling gas under these market conditions and trying to sell it in the United States, they're losing money. And that gets to their intense interest in shipping the gas overseas. This is not about energy independence. This is about corporate profits. So they flipped the leases. In 2010, Chesapeake sold some leases they bought in Texas for $2,000 an acre. By then, people knew more about fracking, were getting more money for $11,000 an acre. I've given a lot of these talks, and I've never met anybody in any of them that got $11,000 an acre. And out of that, corporations make a lot of money, and CEOs make a lot of money. McClendon's wealth is about $1.2 billion. He's got a $20 million resort in Bermuda. He's just announced his retirement. He was doing such a bad job that their stock jumped up 6% when he announced that. But he's getting an exit package of $47 million. That all comes out of your leases. And here's how they fund all of this. So they buy all these leases in New York. Chesapeake and Norris has done the same thing. Norris has assigned portions assigned, that's what they call it, when they sell off a portion of your lease. And Norris has joint venture partners too. But what Chesapeake did in New York was sell off 32.5% of all their leases to a Norwegian company, Statoil Hydro. And by selling off a portion of the lease, they made more money than they paid for all of the leases. This is how your lease is being used, and they're not telling you any of this. So they sold all of the 32.5 to Statoil Hydro for $2.1 billion. And when you look at the 5 largest joint venture partners that Chesapeake has done this with over the last few years, and by the way, the Wall Street brokers and bankers and business people, all of them are making money on these huge deals because they're all getting a percentage. You're not getting any of it, they are. And so the 5 largest joint venture partners paid them $19 million, almost $20 billion, for leases that they only spent $17 billion for. So that's how they're using these leases. This is in Michigan. This is an article that's taken last June, and it was exposed that in Michigan, Chesapeake and Encana were colluding to not bid against each other and pay landowners as little as they could and not compete. In one email, McClendon wrote, let's smoke the peace pipe. I have clients who take offense at that, but, and with Encana, if we're bidding against each other, we're both working to avoid bidding each other up. They're under investigation for this now. This is just how they collude to make more money off individual business owners. They also don't pay taxes. They only pay 1% tax over the 23 years. They paid only $53 million in taxes in 23 years, which is less than half of McClendon's salary in 1 year. Now they're in a lot of financial trouble because they built this business model, and this is North's problem too. They built a business model when gas was selling at $8. And so they thought they could come in and drill the gas and sell it at that high price. It's now less than a third of that. And so the business model doesn't work anymore. When North declared bankruptcy last fall, they blamed the state. It's not the state's fault. It's their own business model because they've drilled so much. And the reason they drill so much is to hold leases by production. We'll come back to that. But they've, not just North or Chesapeake, but these dozens of companies. But Chesapeake is the second biggest company producing gas in the United States. The first one is Exxon. And so they have drilled so much that they have much too much supply and a very low demand, and the price is down. So now they're trying to come back at the landowners one more time. They went in, this is in July, the Wall Street Journal announced that they were trying to force landowners in Ohio to amend their leases. You try to get Chesapeake to amend their lease. I haven't heard of anybody ever having success doing that. And they were telling people, if you don't allow us to change the lease, and what they were trying to do there was increase the size of the pooling unit that they could apply for, and we'll come back to why that would have been advantageous for us. So they're coming back at people, they're not paying. So if you have a pooling unit of 640 acres and you drill one well in it, you encumber all of the leases in that 640 acres. It's called extension by operation. And your lease, everybody's lease, says if there's any operations anywhere in the pooling unit, your lease is extended by that. So the larger your pooling unit, the fewer wells you have to drill in order to extend all those other leases. That's what they were trying to do in Ohio. This is Bloomberg's news. This is last year. So they began to try to reinterpret in its own favor hundreds of leases in Pennsylvania and Texas. There are legal battles all over the place because they are not paying the royalty payments. And here we are in North's bankruptcy. Oh, it was December. I thought it was longer ago than that. So if you have a North lease, you're probably wondering what happens to my lease because of their bankruptcy, and it does not end your lease. In fact, it's probably one of the few, the leases are some of the few assets that North has left. Now, North tried to sell all those leases last August. They went to a gas convention in Texas in August and tried to sell all of their leases in order to avoid the bankruptcy. They'd already sold off their pipelines and a lot of other things, mostly to companies from former executives of North, but they couldn't sell their New York leases. They had 120,000 acres, and 37,000 acres are in western New York, where they claim that there's wet gas. It's not methane that they're after there, it's propane and butane, which the price is a little higher on, although they're now driving that down because of overproduction. They could not sell their leases because even the foreign companies, the Chinese companies and the Asian companies that want to get into the business to learn the technology and get the gas, even they understand that they can't make money selling at this price. So it does not end the lease. And they're trying to find a loan. Not too much has happened. They had a bridge loan lined up, and that fell through. And I don't know whether people are getting any correspondence from North since December. If so, I'd love to talk to you about it afterwards. But your lease is not ended. just because they declared bankruptcy. It's only a Chapter 11, which means they can reorganize and keep the company going and try to see if they can find a way to turn a profit. And these are the talking points. The one that I really love is deal with the man of the house if possible, as men are less likely to admit they don't understand what's going on. Now, a lot of people think, well, I'm going to get a royalty when they start drilling. The problem is, with every term of a lease, you want to look very carefully at the legal language that defines it. And so here's a standard, this is a Chenango County, and Nornu, I think, has now morphed into Norris, but this is a standard definition of how a royalty payment will be calculated. And it's an amount equal to 1/8 of the revenue realized by the company less. So first of all, there has to be a profit. And because the price is so low, there's no profit to begin with. So there's no royalty. And even if there were a profit, they get to subtract transportation costs, marketing costs, treatment, the compression. All of their business expenses come out before you even could ever see a royalty. Less any excise taxes, severance, windfall profit taxes. So because the price of gas is so low, they're not paying royalties under the current market conditions. So that's sort of the first portion, where you just need to understand that as badly as you may feel about your lease, it was a very calculated business decision by the company to get it as cheap as they could, with as much fraud as they can, and then to use that as a commodity to increase their corporate profits. And now, because the leases are 5 years old, most of them, their business model, it contains a very, very strong incentive to extend leases one way or another. And that's what we're going to come to now. First of all, what's in the standard lease, and then what you have to do to end a lease, and the kind of tricks that the companies are using to prevent you from ending your leases. When I first started doing this about 2.5 years ago, I said that I think even that 99% of the lawyers in New York wouldn't know how to properly interpret a gas lease. These are incredibly complex business documents. They're very small print, and there is so much crammed into every paragraph that we're going to talk about that it's very, very difficult to read them and break them down. And so we're going to look at some of the worst parts of them and see what we can learn together. The first paragraph is called the leasing clause. Ellen alluded to this a little bit. And most people think, well, I'm giving them the right to drill gas. Well, yes, but a lot of other things. Compressors. Compressors are very dangerous. They leak all the time. The air pollution coming out of compressors is a very, very significant health problem in Texas, Pennsylvania, and other places. And they can put in roads, electric power, compressors, take water anywhere they can get it other than your well. And they need about 8 million gallons of water per frac. So that's one thing that they get free of charge. The one that really I think is sobering is the ability to store gas under your property from anywhere. And there's a movement over in Watkins Glen to stop a propane storage facility. I don't think many of us understood that we were agreeing to have gas stored under our property. It's in almost every lease I've seen. So those leasing clauses are just totally favorable to the company. You also agree that you can be pooled, and you can't fight that. A lot of giveaways in that standard contract. But I think one of the more deceptive aspects of most leases, and Chesapeake standard lease, and I think Norse also, it has a term, a contract. Usually there's a leasing contract is the first contract, and they describe the physical dimensions of your property, and then they go into the term of lease. And it says right on the standard lease, this is a 5-year lease that's signed in September of 2007 and ends in September of 2012. Looks pretty clear. Looks like it has a 5-year term and then it ends. Well, the problem is the next paragraph. And that's automatic extension. And again, by the time you get down to this halfway down the first page of this 8.5 by 14 document, most people's eyes have glossed over a long time ago. But what it says is that the company can extend a lease at its option, with the landowner having no say whatsoever, merely by tendering payment equal to the amount that they paid at the beginning. Tendering payment. Mailing the check. That's what that means. We just ended one in Cortland County because, and one other thing that this reminds me of, if you have bought a property with a lease and you're the new owner, almost every lease requires you to send a copy of your deed to the company. So please remember that. If you are not the original person that leased, then you need to notify the company that the property has changed hands. And one of the reasons for that is what happened in this case in Cortland County. A professor at SUNY Cortland, as part of a divorce, she got the property. The lease had been signed by her ex. She told Chesapeake that she had bought the property, sent them the deed, and they ignored that and sent the check to her ex and claimed that they had extended the lease. Now, we were able to stop that by getting the Attorney General involved, but only with the lawyer and the Attorney General were they going to give that up. So if you have purchased land with a lease, send them your lease, send them your deed so that they know that you're the owner. And so what says on it a 5-year lease is in reality a 10-year lease. 2/3 of all leases have these paragraphs that have not been crossed off by the landowner. So people, and people don't understand this. I remember a talk I gave last summer between a couple of the Finger Lakes where this 71-year-old widow came up to me and showed me her lease, and it had an automatic extension clause. And when I explained it to her, she broke down in tears. She had an orchard, and she knew that if they were fracking on her land, that her livelihood would be gone. These are, and the landmen never explained these things. So that's one problem with ending leases. Many, almost a majority of them have automatic extension clauses. So that's one trick that they have built in. The other is that all leases have provisions that say that the company can extend by operations. Now, essentially that's a concept that means if they've drilled a well and it's producing, then your lease will extend during the production life of the well. That makes some sense. The problem is how broad these corporate lawyers have drawn the definitions of operations. And I'll just read some of this because it's not English. It says, including any of the following which may occur on the leasehold or lands pooled, unitized, or combined. So again, if they do any operations within a pool, a spacing unit, all of the properties are tarred with that, and all of those leases are extended. Using bona fide good faith efforts to diligently prepare the surface of a physical well site prior to the commencement of actual drilling activities, including but not limited to the commencement of clearing operations on or adjacent to a well site, such as the clearing of trees, the construction of an access road, or the delivery of heavy equipment. Now, you may think, oh, they would never try to use that. It's as if that's not broad enough, or any other looking for gas, or any X similar to the above. So in Pennsylvania, this is an AP story that occurred, well, almost 2 years ago now. it talks about a couple. Young couple owns 117 acres, and they got $2 an acre, so they got a whopping $234. And they were counting the days until their lease should have expired in October of 2010, October 24th. So Chief Oil, 3 days before the 5-year period would have ended, they created a pooling unit. They have different laws in Pennsylvania, and they just create them down there by filing something with the clerk. They don't even have to go through any approval process. And they created a pool with 19 other tracts of land. And then they staked out an access road and parked a bulldozer on one of the neighboring parcels and claimed that that was at 31 hours before the leases were to expire. And they claimed that that parking the bulldozer and staking out the access road was enough operations to extend all 20 leases. And we all know how word goes around our communities, and the contractor tipped off the couple that they were all over us to get that bulldozer up there because they got to lock in some landowners. So that's another trick that they use by operations. It's another reason, and so then now they're in court. That's the problem, and Ellen hit it right on the head. You can have the best lease in the world, and you can write Chesapeake or Norse or Chief or Cabot or whoever, and say, you're violating my lease. And they say, well, that's, no, we're not. And what are you going to do about it if we are? And that's just the attitude they take almost all the time. And your only option is to figure out whether or not you can go to court. And as hard as it is to go to court, first of all, litigating against major corporations is not an easy thing. I've done a little bit of it over the last 38 years. But one of the things we found in New York when landowners down in the southern tier tried to bring a lawsuit about force majeure, and we'll come back to that, is another clause in the lease that catches people. And that is the arbitration clause, which says before you can take them to court, you have to go through arbitration, where you will split the cost of arbitration with the company. Arbitration is very favorable to businesses and not favorable to individuals. And when you start litigating against major corporations, the main thing they do is they try to just paper you to death and run the legal bills up and run the hours up. And you're paying for half of that in the arbitration process before you can even get into a court where you might get a fair hearing. Once some of these cases get to court, we've had some good rulings. But an individual can't take Chesapeake or Exxon or Norse to court. It's just not physically or humanly possible. You'd have to have more money than, you'd have to have a lot of money. The other thing is they'll place just a corner of your property in a spacing unit, and then all of your property is encumbered. All of these things are going on in Pennsylvania. I don't have to make it up. It's all out of the newspaper. So now let's look at what's in a standard lease. We have that first paragraph we talked about. We have the extension clause. We'll come back to force majeure. Delay rental is really not being used anymore. I probably should update this slide. The automatic renewal paragraph, operations. And here's the problem in New York. Remember I said your lease doesn't just end when the 5 years are up or the 10 years are up. This is the New York state law that governs how to forfeiture and cancellation of oil, gas, and mineral land leases. This is New York's General Obligations Law, Section 15304. And like many of the laws that we're talking about, the company lawyers now brag about having written them. And it starts out, sounds really good in the first paragraph, and it says whenever a gas lease expires by its own terms, so that 5 years is up, the company or the assignee, and we'll come back to that, that's the company that they sold a piece off to, shall provide the current owner with a document that can be recorded to cancel the lease. Shall provide. Sounds pretty cut and dry, doesn't it? The problem with this law is there's no sanction, there's no teeth, there's nothing happens when they don't send you that. and they don't send them. And so the lease is recorded in the county clerk. It stays there. When you do a title search to see about a mortgage or selling, you've got a lease on your property. And it stays there until the landowner exercises the second and third paragraph of this law. So when the company fails, if the company fails to cancel the lease, then you can serve notice on them by letter. But you not only have to notice the company that you first leased from, you have to go to the county clerk, look up Norse, and find out if they've filed any assignments. Because you not only have to notify the first company, but all assignees, whether known or recorded. Now, how many people would figure that out on their own? And so if you just wrote Norse and they sold part of your lease to Hearts or Empire, and you didn't notify them with this carefully crafted letter that has to have more details in it than is necessary, you wouldn't end your lease. So you have to figure out how to get to the county clerk's office. Some counties, we're very lucky in Cortland County, all of these things are online. You can just go in and find them really easily. It would be nice if all counties could get to that situation. So you have to send letters not only to Norse, but everybody else that they've assigned any portion to. You have to send it by certified mail, return receipt requested, and make an affidavit of service. We have forms for these letters on the Fleased website, on the Cortland Gas Company group website. We have forms for the affidavit of service. You have to put this much detail into the letter, though. Names and address of the landowner and the companies. I think they'd know their own name, but I guess not. The names and address of the interests of the person sending the letter, if you're not the landowner, the state, the county, the town, the location, the general description of the leased property. If it's in a spacing unit, you have to specify that. If there's a well, you have to know the number and the name of the well. If there's a well, you're not going to terminate your lease because the well is going to extend it by operation, so I'm not sure why that's in there. The date the lease was signed, the date the termination or the basis for such termination. You ought to be able to send them a letter that says, here's my lease. It is expired by its own terms on October 7th, 2012. Send me the cancellation notice. That would be more than enough. They have all these things on file, but this law makes you jump through all of these hoops in order to notice them. The problem here is, so your lease is ended, you don't have anything that cancels it, you want to clear up your title. By sending this letter, you open up a new 30-day window that allows the company the opportunity to file an affidavit in the county clerk and extend your lease. They don't have to say why. They don't have to justify it. All they have to do is they file these just boilerplate statements that say, we consider this lease still valid. And so that, I think, is a very major drawback in this new 30-day window when the lease is already expired by its own terms. But let's assume that you send them this, they don't send it back, they don't answer it, they don't file anything, then you've hit payday. Because then you can take a copy of your letter and the affidavit of service and file it in the county clerk, and the final provision of this law says that filing terminates your lease. That's what Mina just did. She actually had to go through a couple of other steps that shouldn't have had to do, but this is the easy one. The guy that I talked to in Cortland, he had to notify 8 different companies because there were that many assignments over the 10 years that his lease had run. And that's one thing that's happened here. A lot of these leases, particularly the older ones that have been extended, started with small companies that have been swallowed up as this industry has taken off. And so 8 different letters had to go out in order for Mike to end his lease. And so one of the problems here is that every assignee has to be notified, and we've gone through what you have to do in order to find that. You don't look under your name, you won't find it under your name. You have to look under the original company's name. And, you know, Norse has a lot of documents on file. So it depends upon how friendly the clerks are in the county, the assistant clerks are. But that's what you have to do. You have to go find those assignments. And we have sample documents. This is the gas drilling awareness of Cortland County, but Fleased has the same assignments, and their material is here. Instructions and explanations, very similar to what we're walking through here. Some excerpts from the general obligations law, and sample notices and affidavit of service. So that's generally lease termination. And the other thing is I will help people end leases. If you have a lease that you think is expired and you can get me a copy, and my contact information will be up here, I will help you walk through that after tonight. This is not a simple process. It's really not fair to landowners to have to do all of this. That's why we have developed the information and the forms that we have. And every lease I bust makes my day. And we've busted a couple hundred in the last 2.5 years. And we're going to keep at it. So if you have a lease, and this is, I don't expect, well, we have a quiz at the end of this. Probably we didn't tell you that, but I don't expect you to pick all this up, is what I'm saying. If you want some assistance, then let me know, and we'll work it out by mail or email. Email's best, but we'll help you do this. So that's the General Obligations Law 15304. Now, as I said, the companies are desperate to extend these leases. They're commodities. They paid nothing for them. Sometimes $2 an acre, sometimes $5. You know, they weren't paying much when they came around. They're not paying thousands. They didn't pay thousands. And so they want to keep these cheap old leases so that they can sell them to somebody if they can find a buyer and keep this scam going. And so they don't terminate them. They use every automatic extension clause they can. And then both Chesapeake and Norse is still sticking to their force majeure claims today, even though there's been a very clear federal ruling against Chesapeake's force majeure claims that we'll get to in just a second. So force majeure is a French term that means major force. It's essentially sometimes talked about as an act of God. And what that means is that if I have a contract to do something and I'm prevented from doing it by some event that's beyond my control and that I shouldn't have anticipated, then I have the right to extend the period of the contract to give me time to get my work done. If I'm supposed to build your house and there's a lumber strike in Canada and I can't get the lumber, or the road floods for the 2 months, like my road does, and you can't get in there, then you're excused of your obligations to perform under the contract for that period of time. The problem with that is it's being abused by, well, the two companies that I know the most about, Chesapeake and Norse, and they're claiming that because of the New York regulatory situation that is not issuing permits, that they have a right to extend everybody's leases. They sent every leaseholder, and if you have a Chesapeake lease, you got one of these letters back in January of 2011 saying, we're extending your lease, and it's the state's fault because they're not letting us drill. The problem is that that's not a legal use of the term. In November of last November, a federal court in Binghamton issued a decision that firmly and unequivocally rejected Chesapeake's claim of force majeure extension of the 200 or so leases that were involved. And here's some of the language from Judge Hurd in that letter, in that decision. Defendants did not, and that's the companies, did not contract for guaranteed production of gas. They contracted for the access, exploration, and the right to drill for a set period of time. As the drafter of the leases, the companies were in the best position to impose drilling specifications as to the methods and the formations explored. Accordingly, force majeure does not extend the leases. And the reason for that is they can still drill for gas under the current regulatory situation. They just can't do high-volume, slick-water, horizontal fracking in the Marcellus without using a long-form environmental statement. They could go through the full secret process, the State Environmental Quality Review Act process, have a public hearing, and prove that it was safe. They could be fracking today if they would want to do that. They don't want to do that. They could drill into other formations. They could vertically drill. But they don't want to do that. And so the judge said, you're not prevented from performing under this contract. That clause doesn't work. It's based on this 1987 case from New York that very narrowly, courts do not like to, they like to be bound by what's in a contract and don't like to have people changing them afterwards because they have a lot of lawyers. And so they've very narrowly defined what force majeure and when it can be used. They could be drilling. They don't want to be drilling because they can't make any money, and so they're blaming the state. That's what these claims are about. They've even made a claim against the state of New York, claiming to extend their leases in the state forest using force majeure. I think the AG talked them out of that. If you have a Chesapeake lease, you probably in November or December of this year got another letter from Chesapeake, registered mail, claiming that an agreement that they made with the Attorney General's office back in June gave them the right to extend your lease. If any of you have that letter, please let us know, because we think we've found a way to make them give that claim up. And it's a little complicated, and we won't go through it now. But the agreement that they made back with the Attorney General's office was really not very good. It was called an assurance of discontinuance. Now that's legal jargon for the Attorney General agreed to discontinue an investigation they were making into Chesapeake's fraudulent leasing practices because they made an agreement that would stop the investigation. So Chesapeake agreed to let go of 50 leases, 50, statewide. The Attorney General agreed that they had properly extended 1,865 leases under the automatic extension clause, the one that just allows them to do it. And for 4,365 other leases, they created this really paper right that's pretty meaningless, that you can go negotiate with other gas companies, and if you get a better lease, Chesapeake has the right to match it or let your lease go. The problem is nobody's signing leases these days because there's no money in it, and they've run out of money. And so that remedy really didn't, I don't think, benefited anybody. But they're now claiming that this agreement they made with the Attorney General somehow gives them a right to extend their leases until the end of this year. It doesn't. And so if you have that letter from Chesapeake, let us know. We'll work with you to try to get your lease ended. It's not simple, but we think we've figured out a way. We've ended a couple of them so far, and maybe we can get the Attorney General just to make them stop that claim, but we'll see. One other thing that happened last summer that you want to be aware of is that companies, and a number of the counties even, Madison County and I think maybe even Shenango, sent letters out to people, watch out, there's a new set of, a new attack being made on homeowners, and that's to buy your mineral rights. Create a mineral rights deed where people are asked to sell totally the mineral rights underneath your property. Creates what's called a split estate, which is common out west, where you own the surface, but somebody else owns the mineral rights. You don't want to sign one of those, because once you do that, you have no control whatsoever, and it runs forever. It's a deed. A deed doesn't get amended until the person that benefits from the deed agrees that it would be amended. So if somebody has approached you about a mineral rights deed, do not accept it. It's permanent. There's no termination date. You have no control together with the right of ingress, egress, and times for purpose of drilling and storing gas. And the cover letter that came with it was incredibly deceptive. Preserves your estate on the surface. Well, maybe, as long as you don't have one of those gas wells on it. And reduces your risk that the state and local regulatory will prohibit or restrict drilling on your property. We don't even understand how they made that claim. And what they've done is that they've gone back to people who have leases and are not getting any money out of them and saying, look, we'll take that lease off your hand and give you this money, and then they'll get whatever money might come out of that lease as part of it. So don't sign a mineral rights deed. You give up all control whatsoever. This is the letter that I was talking about from Chesapeake. If you got one of these, let us know. So that's generally what I wanted to talk about. We've talked about compulsory integration, operations within a pooled unit. In some of the newer leases, you can sort of see the evolution of these leases as corporate lawyers have lost cases in other states. They've tightened up the language, even ratcheted it down against the homeowner even more. And most of the leases that we see since 2008, 2009 have this no automatic termination clause, which says this lease shall be construed against termination. In other words, it should run forever and no court can ever take a look at it. I don't know how well that'll handle, what a court's going to think of that. I don't think they're going to think much of it. I don't think that's going to get the company that much. But it's just language they keep adding in order to try to keep extending these leases because it's part of their business model. You have, Ellen has touched on insurance, landowner liability. There are banks now that will not write mortgages because it creates too much of a liability, and they can't necessarily foreclose and get their money back if your land has been leased. So you want to watch out for automatic extension clauses. You want to watch out for force majeure letters. You have to know what an assignment is and where to find them, and you must act to end your lease. So what happens if your lease is, you've been counting the days for that 5 years to end, and then you, after tonight or whenever, look back at it and you have an automatic extension for another 10 years. That's not the end of the world. It's very crushing to a lot of people once they figure that out, but there are other protections. And it's the kind of political activity that Ellen talked about a little bit. First of all, we can put pressure on the governor. You can put pressure on your state senators, too. The Assembly last week passed a bill that would have a 2-year moratorium until May or June of 2015 by a vote that was overwhelming. Now we have leaders in the majority in the Senate that are swearing that bill will never get to the floor, but we have a different Senate this year, we're told. We'll have to see. But that bill would be a very good bill for both houses to pass and for the governor to sign. And what they're saying is, let's see what these health studies show before we allow this in New York. So that's political activity on the state level is very important. I think that Governor Cuomo in the last year has understood that this issue is not going to be good for him politically. And he has one rule. It has to do with 1600 Pennsylvania Avenue. And if he thinks that this won't help him get there, he's not going to allow it. And so the more letters and calls that he gets, the safer we all are. And the other level that people have had a lot of success on is having your towns use your home rule protection powers, using your zoning powers to ban fracking. And that really has the companies upset. They are suing towns. There are 3 cases that have been filed, that have been decided in New York. Probably most of you have heard about Dryden getting sued. Middlefield got sued. And the city of Binghamton got sued. Each of those decisions decided clearly and unequivocally that towns have the right to ban fracking. The difference there is that the state environmental conservation law says only the state can regulate this. What's the setback? What are the rules about how the drilling is done? A town can't regulate it. You can't say, oh, you can't put it next to my elementary school. You really can't say that. You can say, you can't do it anywhere in our town, or you can't do it in these zoning districts. And the towns that have done that, and the court cases that have decided that, have ruled squarely and unequivocally in favor of the right to do that. Now, you may have heard pro-drillers or landowner coalitions say, well, the Binghamton law got struck down. It did, but it was a moratorium that was formed in a very different way. And what the judge in Binghamton said was, you have the right to ban fracking, you just didn't do it correctly, so go back and do it correctly. But you have the right to do it. So towns are told all the time, you don't have the right to do this, we're going to sue you if you do this. That's what happened in Oxford, I understand, where they came in and promised to sue. And we have legal teams that now represent towns without charge in order to protect against that kind of threat. It takes a lot to get a town to pass first a moratorium while you look at your zoning law and figure out what needs fixing. But we're involved in that in my town of Preble. There are a lot of town boards that I've heard about that just won't respond to their citizens, but you just have to keep at it. And citizen action is working well. The problem in our town is our town lawyer. The board wants to do it, and he keeps preventing it. So we're going to move him aside. We've just agreed to do it. So we could sit here all night and tell lawyer jokes, but that wouldn't get us anywhere. So towns, home rules, that's really the best protection. And it's a good way to work with your neighbors and protect your land and your water. These are the local organizations that I was asked to list. You probably are more familiar with them. There are a lot of organizations here. That's another thing I really want to talk about a little bit. You know, I've been, last week was my 38th anniversary of becoming a lawyer. I've been doing some interesting legal work in New York during that 38 years. I have never seen a political movement like this, where people, once they understand how much danger is created by this industry and how they're not playing fair, they get involved. And it's really a pretty inspiring movement to be involved in. And it feels really good to have meetings at your house with your neighbors where you actually can make a difference. You know, I've been to Pennsylvania, and I've visited homes whose wells have been ruined. And those of you, we all have wells. Once your well's gone, your life is gone. It's even worse than that. The people with constant rashes and severe health problems that are created by the chemicals and the methane that leak. This is a very dangerous operation. And the way they keep a lot of this quiet, we were talking about this before, is that first you have to prove that they polluted your well. It's not easy because they keep all their chemicals secret. That's why they won't tell us what chemicals they are, because when they end up in your well and you can say, look, you use that chemical and it's in my well, they claim, oh, it's an industry secret. It's not. They just don't want to. That's just one more layer that keeps you from proving that they polluted your well. Once you've done that, they have gag orders that prevent you from talking about the fact that they settled with you. Which reminds me that last August I was asked to lecture to lawyers about leases, and part of the program was a panel that included the main industry lawyer, and he and a vice president from Chesapeake sat up there and said, we have never polluted a well. There's never been a case where fracking has polluted a well. The day before, Chesapeake had signed an agreement with 3 families in Pennsylvania for $1.6 million to buy their property because they had polluted their well, signed by that same vice president. and they didn't have a gag order on that one. So that's one way they keep you from knowing how bad this is. But it's a very industrial activity. It's ruined hundreds of people's lives and homes in Halton, Pennsylvania. And I appreciate your listening to us, and we'll take questions now. These are some ways of contacting me and Fleased and other organizations. We're going to have to use microphones for the questions. My hearing is really bad. I have the best hearing aids I can, but I appreciate your listening. Thank you.
I have a very specific question regarding our property. We have recently deeded our property over to our daughter, so that we will have life use of it. The deed makes no mention whatever of a gas lease. The abstract of title, however, has a provision in it, if you'll permit me to read it. It's very short. This was signed to the Penn York Natural Gas Corp. It's an oil and gas lease dated June 10th, 1931. And it was recorded in the county clerk's office in Shenango County. Covers all that parcel of land bounded and described as follows. I won't bore you with that. It's fairly brief, but at any rate, the thing that perturbs me at the end is lease to remain in force 20 years and as long thereafter as oil, gas, casing head gasoline, or any of them can be produced. End of thing. Am I in trouble?
My sense of these things is that in our dealings with Joe, for him to have something in his hand to look at makes it a lot easier for him to respond. So I don't know whether you can respond to that now, Joe, or whether you'd like to have a physical copy and be able to look at it.
I can give you the photocopy I have of that provision, or I don't know that you want to have the whole abstract of title, which I don't have with me.
Well, let me try. From what I understand, you have a very old lease, had a 20-year term, and that 20 years is over.
That is over.
But nothing has been done to be filed in the county clerk's office to cancel it yet.
True.
Then, under that law, it still is a cloud on your title. And you need to consider sending a notice. The company may not even be around any longer. That's a problem that you have. And then
operating under a different name.
So it's very difficult to find those old companies, but I would recommend that you still file the notice letter under 15304, because anything short of filing a cancellation document, either directly from the company or the kinds of letters that we walk through, sending the letter and the affidavit service, if that's not done, that's still on your title. It's still a cloud.
And we don't even have a copy of the lease, of course.
It should be in the county clerk.
Okay, so my task is to appear at the county clerk's office and get their assistance in seeing whether that lease was sold to other people and notifying them.
That's correct. And you may find that there's a cancellation document filed also. I doubt it. But other than that, it's still, I don't know how many have looked at abstracts of title, but it's still filed against your property, and you're not completely clear of it until you take the steps that we talked about before.
Thank you very much.
You're welcome.
I hope you'll permit me to be excused because I have some livestock to take care of at home.
I've got an unusual situation, but I guess many of the people here will have their own particular situations. I originally signed a lease for 2 non-contiguous parcels, and that was in 2007. After that, I sold the non-contiguous parcel to somebody else. After that, Norse drilled and incorporated that person's property into that unit. So 2012 passed, and I did not get any notice of renewal on the parcel that I still retain. So along the way, I was just kind of assuming that the parcel in front of me is being held in production. But now I'm wondering, if somebody else bought that parcel belongs to him, not to me. Therefore, the parcel in front of my house, non-contiguous, should not be considered to be held in production. What do you say? What do you think?
Well, that's an example of the companies doing what they please, and landowners getting shortchanged.
We have a lease that was coming due at the end of last month, and we got the money and the form from them in the mail to send back, which we did not. And I took our lease to a lawyer and asked. She has done some work with gas leases, although she's retired. And she thought maybe our lease was not, that we could get out of it because it was never notarized, and there are spaces on the lease for notarizing. Is this possible?
Most leases don't require that the landowner's signature be notarized. What I've seen is that the landman goes in before a notary and says, I witnessed these signatures. Now, I'd be glad to look at that afterwards. It's pretty hard to speculate about what's in an individual lease, but I'll look at that and give you a better opinion. The problem is, well, so let's look at that, and then I can, and if you can either leave it or send it to me, or the best thing is to scan them and email them, but we'll look at that afterwards if that's okay.
Hi, I'm John Olashauskas, and I've been to almost all the meetings. One large meeting I went to was in Albany, in which it was for the, I want to say the upper management of the government for the meeting. They covered gas production leases and all the laws and the details. They also covered, talked about ethics. And as we're sold the idea that we're getting off of foreign oil as part of the sales brochure, and then all of a sudden now we're selling our land to foreigners for a pittance, it's a lie. It's a misrepresentation. As we were sold the idea was NYRE was coming through and our towns didn't know anything about it, and then all of a sudden we found out they'd been talking about it for 4 or 5 years prior to our acknowledgement of it, and the towns were on top of this and actually been notified. We see this extortion start to take place. So anyhow, as they got done with the ethics portion of the meeting, I asked the question, I says, number one, laws are made on fraud. I said, almost every law that you bring up, the idea of fraud is initiated into the law for this possession. And now we talk about force majeure or whatever else, and or law of contract, that this law of contract is binding because it's law of contract. But if you attach that there's a fraud attached to it, it's no longer binding, but that's not talked about. It's like it's beyond being talked about. And then, again, as the laws were made by the government, where you were sold the idea that New York State was going to follow the procedural procedure of other states as they produced land gas production, and the other states to have a seismic testing done, they had to ask permission, they had to get permission, pay you for the lease.
Shall we ask for a response?
Yeah. You know, it sounds to me as though you feel the way I have been feeling, which is, how in the world can they be getting away with this? It is immoral, it is fraudulent, and as I said, 2 years ago, I just couldn't believe that it wasn't illegal. And unfortunately, what we're dealing with is unjust and, as I say, fraudulent and wrong, but we can't prove much of it as illegal. So unfortunately, that ties our hands. So you need to hold political people accountable, and there's money in people's pockets that we are not happy to see go there, but that doesn't make it necessarily illegal.
One of your slides indicated one of the things we could do is to involve the Attorney General. My only experience with the Attorney General regarding the fraudulent activities of Norse was that they said they could not do anything but just act as a mediator. What do you suggest?
I have been incredibly frustrated, especially because the current Attorney General ran on an anti-fracking platform. And as I said, Joe and I and several other people met with quite an assortment of people from the Attorney General's office and thought they were maybe going to do something. And what they came up with was that AOD, that agreement, which was terrible. The attorney out of the Binghamton office who's handling gas cases has been doing this for a long time, and he basically shows up at meetings and says, essentially, if you were stupid enough to sign a lease, there's nothing we're going to do about it. One of the things Joe was saying that we are pushing with these Chesapeake letters that came claiming force majeure and basically using that agreement to hold people. We've been working with Joe. We are so fortunate to have Joe. Filing complaints with the Attorney General's office. And so far, we're beginning to send more and more. We want it to be a groundswell. Do I think that they're going to take action on individual things? They did forward the complaint on to Chesapeake, and Chesapeake then responded by canceling that lease. It was one, and we've got more in the works. So we're trying to get a record there and trying to get them to take some action. It's frustrating, but I would urge you, it can't hurt to send in a complaint form. The more they hear, I mean, what they actually said they were hearing was, gee, we're just hearing from people who are angry because they didn't get enough money for their lease. And we're saying that isn't what most people are angry about at this point. So noodle them. Do I really think it's going to work? Probably not. But Joe and I are certainly going to keep at it and see if we can rattle their cage. Did you want to add anything, Joe? Okay. One thing I wanted to mention, Joe was talking about town bands and how exciting it is to be part of something where there really is a grassroots activity. And at one point, maybe a year and a half ago, people said, gee, it's too bad there's so many different organizations and we all ought to get organized and be one. And I say, I think it's great that there are so many organizations. Then we can't all be written off as one organization. There are many, and it's grassroots. The town I'm in was one of the early ones to get a band going, and there's an organization called ROUSE, R-O-U-S-E, which is out of Caroline, and they have started a new project, and that project is to encourage local communities to get working on town bands. And what seems to be quite effective, it's what happened in Caroline, and I think it's happening around the state, is first to go door to door with a petition. And I did it in my neighborhood, and I was nervous because I knew a lot of people had leases in my neighborhood, and I was afraid that if I went to their door and I knocked on it and I said, are you in favor of a town either moratorium or ban, depending, and I think we went right for a ban. I was amazed. Out of the 25 households I went to, all but one signed. People with leases realized that they were at risk. In fact, people with leases are the ones at the greatest risk. The only person who didn't sign was somebody who said, I know somebody who works in the gas industry and they say it's okay. Everybody else signed. So the door-to-door petition is effective. We got, I think it was 70% of the town residents signed a ban, petition for a ban. It's huge. And in most communities, you're finding at least 60% of the population wants a ban. And once you bring that to your town board, we looked at it demographically. It wasn't just Democrats. It wasn't just rich people. It was everybody across the board. So that's a heck of a way to show political clout and force. And if you have to, then you also need to get people to run for the town board who represent their population on this issue. This issue is too important. It's a very big one. So Rouse has got this program going. They're trying to provide assistance to communities, help communities figure out how to go about a petitioning, how to go about providing and presenting data to their town boards, etc. So they're online, or if you need help finding them, I can help you find them.